you.
Okay. All right.
All right. Hello, everybody. I'm glad you're here for the last class. So far, we've looked at the Supreme Court and Donald Trump, unfortunately. Gerrymandering, didn't get very far there with race and politics. Homelessness and the Eighth Amendment doesn't apply. And today it's social media and free speech. Now, admit it, most of us, people our age, have a very visceral reaction to social media. We're on Facebook, if only to post our Wordle scores and keep in touch with our grandchildren. An occasional picture, and to follow our grandkids, although they don't use it very much, I found out. They like other sites. And I'd be tempted to guess that most of our reactions are decidedly negative about social media. Be it Facebook, Instagram, or any of the zillion other apps, they monetize us. They spread disinformation. They use algorithms to feed us what they think we want to see or buy. And it allows mean girls, nasty teens, bully boys, and angry exes to bully and shame and troll us. And all too often, the posts that we do see contain fake news and misinformation. So there ought to be a law against that, right? Why can't the government do something? Well, anyway you cut it, regulation by government of what social media platforms must eliminate or must do, or who can access them, is a form of censorship. It's a form or compulsory speech. And whenever there's censorship or compulsory speech, one's got to ask, who gets to decide? If government can censor this, what's to stop them from censoring that? They shouldn't be able to tell us what we have to say, and don't tell me what sites I can or can't see. We value and cherish free speech. It's right up there at the top of it's right up there in the First Amendment at the very top. Congress shall make no law respecting or establishing a religion or prohibiting the free exercise thereof, that's the religion, or abridging the freedom of speech or of the press, or the right of the people to peaceably assemble and petition the government for redress of grievances. It's right there at the top. Now, I normally don't plug books, but today I'm going to plug two more. Anthony Lewis unfortunately is no longer, I don't think he's with us anymore, but he was a fabulous legal scholar. And he wrote for lay people. You didn't have to be a lawyer or a scholar to get his books. How many of you have ever heard of a book or read Gideon's Trumpet? It was the story of how everybody got the right to counsel. Well, Lewis had two other books that I'm going to plug. One is called Make No Law, and it's the story of freedom of the press. And the other one is he calls it a biography of the First Amendment. It's called Freedom for the Thought That We Hate. And they're both great books. They're very readable. And if you want to know anything about the history of more than what I'm going to give you today, this is where I'd recommend you go. When I taught at UCLA, occasionally I would have my wife read books that I was thinking of assigning to make sure that you could get it. You didn't have to be a lawyer or an academic to enjoy the book or get something out of it. And these are two books that I assigned. And when I taught constitutional history, the students hate it when I assign cases to them because those things are impossible to read. But they love these books, so I highly recommend it. This term, the Supreme Court had a number of cases that looked at free speech in the context of social media. What I'm going to do is summarize the historical background of the free speech amendment and some of the important legal developments to provide context, because as with most issues involving the Constitution, it's not simple. And I'll put it together with social media, and then at the end, I'll dig into the cases. So where to start? My kids used to complain, short answer, Dad, so I'm not going to start with Hammurabi's Code. But I will start in 1735 in colonial New York. Colonial laws on speech married British law at the time. one didn't need a license or prior approval to print or distribute anything. That was nixed in the Glorious Revolution. But you had to be careful about what you published, wrote, or said, especially about whoever was in charge. Written defamation is called libel. And if it's about the rulers or whoever's in charge of the state, it's called seditious libel. Hurt someone's reputation or hold them up to ridicule, civil liability and damages. Hold the rulers up to ridicule, and it's the crime of seditious libel, and you go to jail. It was a crime because supposedly such criticism undermined people's loyalty to the government, to the state, and it undermined the security of the state. And since the harm was creating opposition to the legitimacy of the state, truth was no defense. Because the crime was in weakening the way people felt about the government. Because remember, the king can do no wrong. This is the monarchy. And the royal governors are the representatives of the king on site. Now, there was a fellow in 1735 in New York named John Peter Zenger. He put out a small newspaper in New York that had printed articles that accused the royal governor of corruption and dishonesty. Now, he didn't write these articles. The way colonial newspapers operated, people would write in, and they would print what people wrote in, and oftentimes they wrote in under pseudonyms. So Zenger was charged with the crime of seditious libel. At his trial in 1735, his lawyer, a fellow named Andrew Hamilton, who lived in Philadelphia, no relation to Alexander, admitted in the court trial, in his closing argument and in the trial, he admitted that Zenger had printed the articles and that they were libelous under common law. But so is he selling his client out? No, here's what he said. He told the jury that one, truth wasn't a defense, but it should be. Secondly, the press should be free to challenge actual abuses of authority by royal officials. And three, you should disregard the judge's instructions and find my client not guilty. And that's exactly what the jury did.
Last time I had the
We call that jury nullification.
I thought it had a solution. So
Now,
Yeah, I'm so sorry.
those are accounts of the trial
wanna
and
stay
Zenger's
for it, or-
arguments were
well,
published
it's
throughout
kind
the
of a
country.
waste of time because I can only get about
Oh.
1/3.
There was the law of seditious libel didn't change.
I feel
But
terrible.
no
I didn't-
royal governor after that trial
I
ever
can't-
tried to bring a newspaper to
I
trial
was-
for seditious.
Normally it
libel.
would be easy, just plug in.
And
but-
so when you're talking about where did free speech start in this part of the
I feel
world,
terrible.
you point to Peter Zinger's
Back
trial.
up and go.
Let me just see this over here.
By 1787, after 50 years, 3 states had declarations of free speech in their state
and
constitutions,
Richard
and another
Hansky,
10 had
please
declarations of freedom of
yourselves.
press in their early state constitutions. That's before the federal constitution was written or adopted. In 1788, when the federal constitution is up
Thank
for
you.
ratification, Massachusetts, New York, and Virginia ratified it only after Madison made it known that he would support adding a Bill of Rights to the federal constitution once the government was up and running. And that's exactly what happened. And we have our Bill of Rights. The First Amendment says, and I'll read it again because it's music to my ears. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press or of the right of the people to peaceably assemble and petition the government for redress of grievances. There it is. Now, in 1835, the Supreme Court held that this is only binding on the federal government because it says Congress shall make no law. And that people should look to their state constitutions should they have any questions or concerns concerning abridgment of freedom of speech. And that lasted until the 1920s for speech in the press and 1930s for religion. Now I'm going to break a minute. We're going to run through some slides. You can change the first one. I once gave a talk. There's an organization called the Constitutional Rights Foundation when I was Constitutional Rights Foundation. And every year they would have a conference for middle school and high school civics teachers. And they would have people come in and lecture them. And I got invited a few times. And one of the lectures I gave was called Compromising Civil Liberties in American Tradition. Because in 1798, Congress passed the Alien and Sedition Acts. And it made seditious libel a federal offense. And it was basically there because the John Adams was up for re-election, and the Jefferson Party was really taking pot shots at him. And they wanted, there was also what they call a quasi-war with France. There were some problems there. And Congress, Adams asked Congress, and Congress passed, the Federalists in Congress passed a law to try and squelch opposition. And it was the Sedition and Alienation Acts. Next one. In 1835, the House of Representatives was getting a ton of applications about ending slavery, and this was causing a lot of disruption. So the House of Representatives actually passed a resolution, and this is it. Resolved that petitions, memorials, and papers touching the abolition of slavery or the buying, selling, or transferring of slaves in any state, district, or territory of the United States be laid upon the table without being debated, printed, read, or referenced, and that no further action whatsoever shall be had thereon. So the House of Representatives basically told the people, even though it's in the First Amendment, you can't petition us regarding slavery, because if you do, we're going to ignore it. At the same time, in 1832, people in the southern states, the leadership was complaining about the fact that Garrison's newspaper, The Liberator, which is against slavery, was being mailed into the South. So this Jackson authorized the post office to issue a regulation that said that we're not going to deliver that newspaper to any subscribers in the South unless you ask for it in writing. And if you do, we're going to publish your name so everybody in the community knows. And that was so much for freedom of the press. You can switch. During the Civil War, Abraham Lincoln, on his own, because Congress was in recess, suspended the writ of habeas corpus and threw a bunch of politicians in Maryland, including the governor and the chairman of their state legislature, in the jail because they were urging secession, because Maryland was a slave state. And in 1862, there was this area of southern Ohio was called the District of Ohio, and it was under federal martial law. And there was a Ohio politician named Clement Vallandigham, who was actually a member of the Ohio legislature, who was giving speeches arguing that conscription should be resisted and the government should make a deal with the Confederacy. He was thrown in jail by the Army. A military tribunal tried him, sentenced him to life in prison, and Lincoln changed that and exiled him, had him basically escorted into the South. He went back, escaped through the blockade, went up to Canada, came back, and was elected governor of Ohio. So that's during the Civil War. In response to World War I, the United States Congress passed the Espionage Acts, and under that, people were thrown. Eugene Debs was thrown in jail. He was running for president while he was in jail. The Palmer raids. Palmer was the Attorney General. Basically, the government raided all the left-wing offices, including this is the picture of the IWW office. Emma Gold and a lot of people, about 500 people, were forcibly deported. They were mostly leftists, including, I think one of the famous ones is Goldblum, who was, and I have another picture, I didn't bother putting it up, of her deportation order. So much again for this. In World War II, we have another one, if you could, one more slide. Of course, we all know about Japanese internment. Again, civil liberties. One more. You've got the McCarthy era. And then, of course, you have one more, you get the Patriot Act. So this is, the Bill of Rights are great, but I just want you to know that it's been a fight. And we have kind of an American tradition of disregarding them. As you can see, this has happened often enough that it's not an anomaly. There's so much for that American tradition. We celebrate the Bill of Rights and the First Amendment, but we should be aware of the fact that, hey, it's a struggle. It's always a struggle. Every generation has this struggle again, because it goes against human nature sometimes to allow too much freedom. People are really upset and concerned about other things that seem to take priority. Okay, could you go back to slide number 5, which is the one with Debs in jail and Shank and the Shank case? That's it. Okay,
This one.
that's it. Okay. The first Supreme Court case that arose from prosecuting someone for anti-war publications under the 1917 Sedition Act was in 1919. It was a case called Shank versus United States. The defendant, Shank, had circulated in anti-war and anti-draft pamphlets to men who were about to be conscripted, objecting to the war and urging them not to report for induction. He was convicted in federal court, and the Supreme Court upheld the conviction. Oliver Wendell Holmes wrote the majority opinion, and he stated that wartime presents special circumstances and speech that constitutes a clear and present danger to cause any harm that Congress has the right to prevent, here resistance to the draft, isn't protected by the First Amendment. And he wrote, there was no more right to urge opposing the war and the draft than to yell fire in a crowded theater. Very famous case. Within a few years, Holmes realized he was wrong, and he would start dissenting in more and more cases that affirmed convictions under federal and state sedition laws. One of them is very notable. It's 1925's case called Gitlow versus New York. The defendant lost. Gitlow had been secretary of the New York chapter of the Communist Party. And he had printed a left-wing manifesto, it was called, urging workers to rise up, strike, and take control of the means of production. The majority of the Supreme Court held that the First Amendment's guarantees were so important and in a democratic society that they were incorporated by the Due Process Clause of the 14th Amendment and were now binding on state and local governments. This was called the incorporation doctrine. It was the first time that the Bill of Rights, any aspect of the Bill of Rights, had made binding on the states and local governments. By now, all of them are. The last one to be included was the Second Amendment, which happened in the Heller case, what I talked about a couple of years ago. But even if they were, so the Supreme Court held that what New York State did in terms of free speech was covered by the First Amendment, but Gitlow still lost. They applied the clear and present danger test, and they affirmed his conviction. It wasn't until the 1960s in the Warren Court that the Supreme Court abandoned the clear and present danger test and held that all speech was protected unless A, there was an overriding governmental interest, and B, the speech raised a likelihood of immediate specific acts of terrorism or other harmful acts that the government had a right to prevent. In other words, immediate harm. So the clear and present danger test was gone. And in the case where the Supreme Court got rid of the clear and present danger test, they went back and quoted a famous line from Holmes's dissent in the Gitlow case. That dissent was, the most important principle of the First Amendment is free thought, not for those who agree with us, but freedom for the thought that we hate. And that's where Lewis got that line, and that then became basically American law on free speech. Other cases protected newspaper rights under the First Amendment. Probably the most famous is 1971's New York Times versus United States. How many of you saw the movie The Post, Spielberg's film? Remember that? The government tried to block production and publication of the Pentagon Papers. And in the movie, Spielberg's screenwriters have a character celebrate the money line from Hugo Black's concurring opinion in that case. Quote, in the First Amendment, the founding fathers gave the free press the protection it must have to fulfill its essential role in our democracy. The press was to serve the governed, not the governor. So just as no government can censor political speech, neither can a government compel speech. A publication is free to be as partisan as its owner desires. And for most of our history, newspapers and magazines made their partisan preferences known. Only in the past 70 years have journalism schools come to push the idea that the best press is objective. That's relatively recent when you think about it. Remember the Chicago Tribune in 1948, Dewey wins? This was the rule. Every newspaper, every magazine had a point of view. The Atlantic Monthly, what then was a Republican, a conservative press, the United States Democratic Review was the Democratic Party's outlined in a national magazine. The Nation, which was published very, very popular at the end of the 19th century, was a conservative Republican document. The Los Angeles Times was very conservative. The Los Angeles Mirror was more liberal. The San Francisco Chronicle was on one side. The San Francisco Examiner was on the other. This was the norm. So, what about broadcasters, pre-internet? In 1949, the Federal Communications Commission, which supervised all broadcasters, issued and promulgated the Fairness Doctrine. It obligated broadcasters to give equal time to opposing views on matters of public concern. In 1969, the Supreme Court, in a case called Red Lion Broadcasting versus the FCC, the Supreme Court upheld the rule as a reasonable exception to the First Amendment. There were a limited number of frequencies, and all of them were owned by the public. And therefore, the public interest justified imposing an obligation as a condition of using the airways for profit. So that's, and some of us may remember the Fairness Doctrine. But in 1974, the Supreme Court ruled that Florida tried to impose a Fairness Doctrine on newspapers. And the Supreme Court says, no, you can't do that. It violates free speech. In 1984, the Supreme Court held that public broadcast stations that received grants from the Corporation for Public Broadcasting could not be barred from airing editorials that were critical of government policy. Again, free speech. And in 1987, the FCC eliminated the Fairness Doctrine. And it said, quote, that broadcasters should have the same First Amendment guarantees that the print media have enjoyed since our country's inception. And so much for the end of the Fairness Doctrine. And now we have it. Let's face it, Fox is decidedly conservative. MSNBC is decidedly liberal on the other side. It's clear, our media is no longer, quote, unaffiliated. So political speech has absolute protection. And as a practical matter, so does most non-political speech. Take obscenity. For decades, every state and locality had laws on the books making it a crime to create, print, publish, or even possess lewd or profane or pornographic material. Until the 1990s, US courts uniformly held that such materials which appealed to a, quote, prurient interest, close quote, were outside the protections of the First Amendment. Governments had a compelling reason to protect the good morals of the public and to avoid offending people who might be offended by such material. But courts had a hell of a time trying to figure this out and enforce it. And for decades, justices wrestled over conflicting policies. Protect morality on the one hand or allow free expression on the other. And for years, judges had to read every book or see every film that was brought up. And some of the stories are hysterical. Justice Marshall supposedly would bring popcorn to the Supreme Court's movie nights. By the way, when I was in the public defender's office, they had that in the Superior Court in LA, and one of the judges did bring popcorn. Justice Potter Stewart famously commented that he could not define obscenity, but he knew it when he saw it. And when it came to the internet, the courts gave up. In 1997, the Supreme Court decided Reno versus the ACLU. The Supreme Court refused to use traditional obscenity rules to restrict internet content. It was up to, quote, parents, not the government, to take the necessary steps to protect their children. Especially since most computers in many families are shared. Who can tell who's blogging on, who's looking at it? Hate speech is a different animal, and most states have created civil and criminal rules designed to protect potential victims. People are protected from hate violence based on their actual or perceived characteristics, such as race, gender, sexual orientation, disability, with damages and restraining orders freely given out for punishment. Further, criminal statutes increase punishment for crimes motivated by bias. We call them hate crimes. But speech is not a hate crime unless, one, it threatens violence, and two, it targets a specific person or group, and three, the offender or listener appears capable of carrying out the threat immediately. That's the issue on hate speech. Again, the court's putting these rules together to try and create balance. So up till now, I've talked about free speech in the context of private speakers on one side and government on the other. It's important to keep in mind that the right to free speech means that a government may not censor what is said or published, except where it may lead to actual harm. Individuals and non-governmental entities are not bound by free speech guarantees. That's an important distinction to make. There's no rule that any non-governmental private person or entity has to allow free speech. Newspapers, all of us have an obligation to control speech that might harm another. Defamation, called libelous written or slanderous oral, and hate speech are examples. For defamation, the rules are simple. Make a false statement that causes harm to another, be it to their pocketbook, reputation, or physical or emotional, and you might be liable for damages. Truth is an absolute defense. Now, in Britain law, truth is not an absolute defense. It goes to the measure of damages. If it's truthful, you can't have been harmed very much. That's why you read stories about British trials, and sometimes the damages for libel are 1 shilling because they were able to prove truth. Leon Uris wrote a book about that called QB7, Queen's Bench 7, and it's a libel. It's a libel about a Holocaust denial, and the Holocaust denier sued the person who said he was a fraud, and it turns out that because the Holocaust had actually happened, his damages were 1 shilling. That was the story of the book. Everyone has an obligation to use due care about what they say and not defame another, either intentionally or negligently. If the other person is a public figure, then there's no liability unless you knowingly make a false statement or a specific fact, or that you do so with reckless disregard, i.e. you don't care. But what about social media? Where do they fit in? Because that's what this class is supposed to be about. Now, I gotta give you a disclaimer. I am no techie. I am, like many of us, I came to a computer late in life. My wife how old was I? When did I get that? I was when I got my first computer. I finally got a Kindle when I went to France in 2015 and realized I didn't want to carry books with me. And I got a flip phone. I had one of the first car phones, you know, those things that sat up in your head, because that's what lawyers were supposed to have. So, but what follows, I'm thinking of so-called open platforms such as Facebook, X, formerly known as Twitter, YouTube, Instagram, TikTok. On the one hand, they are like newspapers and broadcast media, because like all media in the United States, they are not owned or controlled by the government. And they profit from advertising. But they're different from conventional media in that social media platforms are also mainly conduits for content posted by their users. Imagine a publication or a radio station that publishes or airs only letters from the editor, letters to the editor. Newspapers don't publish every letter, only those that its editor thinks worthwhile to that paper's readership, and they're always edited. And social media sites do something like that. What a user sees is not everything that others may have uploaded or posted on the platform. We see what the social media entity has selected for us based on any number of factors. Our preferences, what the algorithms of the platform select for us, or what the administrator of the site believes is appropriate or within the site's policies of what posts may be shared with others. The platforms invite users to comment on or repost what users see and hear, but sometimes they don't always allow those to go out to everybody. Anytime that the platform takes any action that either limits, changes, alters, makes a comment about, or anyway, or selects who gets to see what, that's called moderating content. And I'm using that term because it's kind of it's a legal term, and it helps explain some of the cases because they talk about moderation of content. So I wanted to make that clear. Social media platforms, they try and keep people on their sites as often and as long as possible. Why? Because that's what advertisers pay them for, access to our eyes and ears. And it's important to note that. Now, so that leads us to the laws about social media. And I think, although I've only gone for a half an hour, this is a logical place to break. So let's, any questions about what I've talked about so far? Yeah, Constantine.
I remember there was a big flap about Playboy and the magazine and what that was, you know.
Actually, I think you're thinking of Hustler.
Oh,
And the advertisement was one where it was they parodied a Campari advertisement, and it was about Jerry Falwell's first blowjob. And Falwell sued the magazine for defamation. And because Falwell was a public figure, the court said, this is satire, it's protected by the First Amendment.
Oh,
That's the one you're thinking of.
that's what I thought.
Could you just repeat the question for the room?
Well, the question was, Constantine asked, what about a magazine? He thought it was Playboy that had been sued for defamation based on an advertisement that hurt somebody's feelings. And I mentioned it was actually Hustler, and it was Jerry Falwell, and it was a parody that made fun of him. Yes.
In the case of Julian Assange and the Wikipedia case, what do you think about that?
Okay, the question is, what do I think about Julian Assange and Wikipedia? What Assange did was he got access from a third party who wasn't supposed to do it, of secret government information, that he believed the public had a right to know, and he broadcast it. And he realized it. And the United States went after him, and he finally agreed to extradition and pled out no contest for time served and got no jail time. That's what happened. I think it's like the Pentagon Papers case. And you know, how many of you ever remember the TV show Beretta?
Yeah.
Don't do the crime unless you can do, if you can't do the time, don't do the crime. That was the message. And I would say the same thing. Yes, there are rules that this should not be disclosed. Yes, the public should see this. Yes, it may be a situation like the Zinger case. Maybe that's a proper case for jury nullification. That yes, it's against the law. Maybe some civil disobedience is warranted. But when you commit civil disobedience, do it with the knowledge that there may be a penalty. don't do the crime if you can't do the time. And so that's what I think about it. And it depends. The person who leaked it to Assange, he gets no protection at all. Maybe he did a good thing in leaking it to Assange. Assange's a private person. He has a duty, if he's an American, he has a duty to obey American law. Should he know that this stuff is not for public dissemination? Hell, it's got top secret or most secret stamped on every one of it. That lets him know that this is not for public distribution. He chose to disregard that. He made a choice. I think it's the right choice, but it comes with a price.
Right. That's right.
That's what I think. Yes, sir.
Quick question though about the Paramount decree. That was the United States versus Paramount Studios in 1948, which led to the demise of the studio system. And I'm just curious, reading about this though, and about the potential breakup though of social media, for example, Google being forced then maybe to sell off YouTube. And just, what your thoughts are about that.
Okay, the question was asked about my thoughts about the situation where Paramount was broken up and what that happened with Paramount Studio that ended the studio system. And what had happened is they basically held that studio contracts that bound artists to act only for that studio violated antitrust.
Yeah, not only that, but also that they couldn't own theaters, movie theaters.
Right.
Post-production.
Exactly, because it violated antitrust. And that's what supposedly broke up the studio system. Does that apply to social media? First off, that's a separate issue. And I would have to say that I haven't prepared. I would want to prepare myself and look into that issue more carefully before I basically spouted off like I knew something about it. So I'm going to have to bow out on that. That's a separate issue, and I don't know enough about it as I can. So now let's get into what this class is really about: the development and legal history of the internet and its regulation. Now, I'm going to start by saying that these are subspecialties of scientific technological history and of intellectual property and communications law. Intellectual property and communications law was not my specialty when I practiced law. And as a historian, my specialty was not scientific, the history of science per se. So some of this is, I tried to be as accurate as I could. I had a friend of mine who is involved in He has technological expertise to review some of this language, and he approved it. So let's hope it works. And I'm going to start with an analogy. Analogies are really helpful to understanding change over time. And that's what history is. Think about automobiles and the internet. Think about automobiles were at the first half of the 20th century and what the internet is in the first quarter of the 21st century. Just as automobiles constituted a revolutionary technological development that had vast social and cultural implications, so too does the internet. Massive expansion of personal mobility and expansion of instant communication and information have commonalities in the way they affect us. And in each case, it's taking years, decades actually, for statutory and case law to develop as car culture transformed mobility and as internet law transforms communication. So a lot of what we're seeing in terms of law of the internet is experimental because this is new. And this has vast social and cultural implications that it's going to take time for the law to adjust to. And I think that's an important concept to get at the beginning when you think about this. It ain't cut and dried, folks. So let's start with some basics. Like print and broadcast communications, in this country, the internet is dominated by private for-profit entities. Usually corporations whose stock may be publicly traded, but its majority control is in the hands of certain individuals. Or groups. The 1930s Communications Act, which created the FCC to oversee print and broadcast media communications, was expanded to include entities that operate through the internet. So that's already happened. The 1930s Communications Act was amended to include internet communications. Other federal and I think it happened in the 1970s, but I'm not sure about that. I didn't look that specific one up. I just found that it was covered, and that's as far as I went. Other federal statutes enacted in the 1990s brought the internet under international copyright rules, established rules designed to protect copyright owners, minors, and it addressed sex trafficking concerns. Under the Obama administration, the FCC adopted rules for what they called net neutrality. Trump, in his first administration, canceled them. Net neutrality means that internet service providers can't make distinctions between different kinds of lawful content. They can't slow down or block content from one entity and that they don't do to another because that other entity may pay them more. And that was it. So if a service got money from Netflix but didn't get money from Apple, they couldn't speed up Netflix's transportation, but have Apple go slowly. That was what the idea of net neutrality was for. The Biden administration tried to reestablish net neutrality, but I think they ran out of time because you got to go through certain hoops, and it may not have been reestablished. If it is, I'm sure that the new Trump administration will try and get rid of it again. Because there's a federal scheme of regulation, a good argument can be made that federal laws and regulations trump state and local laws. Now, the legal term for trumping, where federal law trumps state law, is preemption. That if there's a federal rule of something, it preempts state regulation. And it's a technical legal question. If the intent in passing the federal law was to preempt state law, then if that intent was implied, then preemption should apply. The Supreme Court has not ruled yet on whether state law, federal law preempts state law when it relates to internet regulation. That issue has not yet been determined. There's no case on it. And the two cases that I'm going to talk about in a little bit don't talk about preemption. Interestingly enough, I think they should. Now I'll explain why later. Just like newspapers and broadcasters under the First and 14th Amendments, social media platforms have free speech protection from most government censorship. But unlike broadcast and print media, social media platforms are immune from civil suits by people harmed by third-party posts, even those posts that the platform may have edited. Why this difference? Why is the internet not subject to civil suits where print and broadcast media is? The answer comes in a law that was passed in 1996. And it provides that during the Clinton administration, the idea was they wanted to open the marketplace and encourage companies to go into the internet and to encourage internet companies for communication purposes. That there was a public good in having people be able to communicate freely over the internet. That this was a public good. And in some ways it is. You know, text messaging is a very convenient way to let my stepdaughter know something when I know she won't answer her phone. And for people who want to communicate with me, texting is really a good idea because my phone is always on silent. For years, I had to talk on the phone to earn a living. I don't like to talk on the phone anymore, so I leave it on silent. So in that sense, so what did the government do? They said that internet entities should not be liable under defamation laws for posting content provided by third parties, by others. The rule is named Rule 230 after its section in the statute. And it states that under the law, internet platforms, and the legal term is interactive computer services, are neither publishers nor speakers of content provided by third party. Which means that if the newspaper, if you write a letter to the editor and and the editor just screws up and lets that editor that letter get published, or a reporter writes a story, or a freelancer sends in a story and the newspaper prints it, and that whatever it prints is actually defamatory to someone. It says that that so-and-so says that a engineering firm is incompetent. Now, that engineering firm is not a public entity. And if you say they're incompetent, you might damage their reputation, and you certainly hurt their pocketbook. And there's a cause of action there for defamation. And because the newspaper publishes it, even though it didn't write it or provide the copy, it can be sued. But if an internet company says that publishes a post, puts out a post, and transmits a third-party post that says that so-and-so engineering firm is incompetent, the internet company cannot be sued for defamation under Rule 230.
Can the person who issued it.
The question is, can the person who issued it be sued? Yes, but, and here's the important but, we all have the right to post anonymously. So unlike newspapers and broadcasters, internet companies are not responsible or liable for defamation based on third-party posts. And since free speech protection includes a speaker's right to speak anonymously, third parties are free to post anonymously or under pseudonyms. And that's what happens. And any law that to the contrary would become subject to free speech challenges. Now, Rule 230 allows social media entities to self-censor content as they wish, provided in good faith. Slide 9. Here it is. These are Yahoo's terms of service, and I'm going to read them. They're typical of most. You acknowledge that Yahoo, ! May or may not pre-screen content, but that Yahoo, ! Its designees shall have the right, but not the obligation, in their sole discretion, to pre-screen, refuse, or remove any content that is available via the Yahoo! ! Without limiting the foregoing, Yahoo! And its designees shall have the right to remove any content that violates the terms of service or is otherwise objectionable, close quote. All this is called moderating content. And Yahoo! Is very typical. So to summarize, the legal framework is that social media concerns are private, for-profit entities that have free speech protection from government dictates of what they can and can't publish to the same extent that newspapers and broadcast media have. But under federal law, social media are obligated to respect copyright laws and child protection laws. But they can't be sued based on anything a user posts on their sites, no matter how harmful, untruthful, disgusting, misleading, or whatever. Now, I noted from a New York Times article on November 7th, which was, I think, was that election day? The date that shall live in infamy?
2 days after.
2 days after, okay. I'm going to call it November 9th, the date that shall live in infamy. The Australian government will be considering a proposal to bar people under 16 from accessing social media sites. This was announced at the Australian government. Anybody else read this? It was in the New York Times. Purportedly, the legislation would make the platforms themselves responsible for enforcing the rule. Sounds like a great idea, huh? Before you get all excited, think about one, the power of the advertisers and social media lobbies. You think that's going to get past K Street in this country? Further, it may well be unconstitutional for government to require that social media platforms do more than post an age warning on their homepage. Too many computers are shared. And if someone under 16 is accessing it, how are you going to enforce it? How is social media going to enforce it beyond just putting a disclaimer up? Computers are often shared, and Reno versus ACLU held that protecting kids from harmful material on the internet was up to the parents to police what their children accessed online. So that's what I think of the Australian thing. I just think everything on Facebook, the first thing when you log into Facebook, you're going to say, if you're under no age, you shouldn't log on. How much good do you think that's gonna do? Do you think a 16-year-old is gonna not log on to a porn site? Which takes us to the three cases that decided at the end of this term. All three involve complaints that social media entities unfairly favored liberal views. One case involved a private suit by state officials and private users seeking an injunction against a litany of federal officials that for attempting to persuade, induce, or suggest that social media platforms limit distribution of third-party posts. The other two cases decided together involve the legality of fair comment laws adopted by Florida and Texas that purportedly limited how social media platforms could moderate third-party content and required that platforms give third notice to any person whose posts they did moderate. That's what two states did. Let's talk about the first one. It's I don't have a slide on it. You can in fact go back to slide one unless everybody's read Gallen's terms of service. How many of you have ever read the terms of service on any site? You might if they're going to charge you money, but it's a free site. Okay, the first is Murphy versus Missouri. 2 states and 5 individuals jointly filed a civil suit against certain federal agencies, and they listed them: the National Institute of Health, the Center for Disease Control, the CDC, the Department of Justice, the Federal Food and Drug Administration, the FBI, and the FCC. And they sought to enjoin those agencies from suggesting, inducing, or persuading any social media site to, quote, censor, filter, comment on, fact check, or limit any third-party posts. The plaintiffs alleged that the government officials from these agencies had leaned on social media platforms to alter and limit distribution of certain posts, mostly that were anti-vax posts, stuff that talked about COVID, or political posts that favored, fact checking some of the Republicans, some of the crap that was coming in. The plaintiffs alleged that they leaned on the platforms to the point of coercion to suppress or limit posts concerning COVID in the 2020 election as being supposedly false, misleading, or influenced by foreign interests. Plaintiffs argued that this constituted government interference with third-party posts so as to violate guarantees of free speech. The district court, the judge happened down in Texas, was a Trump appointee, agreed with the plaintiffs and issued a sweeping injunction against the federal government pending trial. And the Fifth Circuit, also down south, which is also very conservative, agreed, holding that federal officials were so directly involved in monitoring third-party posts to make the government responsible for the platform's decisions concerning how such posts were distributed and shown. Now, that's what the lower courts held. The Biden administration appealed to the Supreme Court. The court ruled 6-3. How do you think they ruled? You're wrong. The court 6-3 reversed, canceled the injunction, and ordered the case dismissed. Who were the 6? Roberts, Kavanaugh, Barrett, and the 3 liberals: Sotomayor, Kagan, and Jackson. Now, Barrett wrote the opinion. Now, here's how opinions get decided. You ever wondered who decides who gets to write the opinion? Here's how it works. If the Chief Justice is in the majority, he gets to assign the opinion. He can assign it to himself or one of the other justices in the majority. If he's in the minority, then the senior judge, the judge with the most seniority, who's in the majority, gets that privilege. So that's why, in this case, Justice Barrett wrote the opinion, and Roberts, Kavanaugh, and the 3 liberals joined it entirely. The court held that the plaintiffs lacked standing to sue.
Right.
The Supreme Court said, standing is a preliminary issue. If a plaintiff or plaintiffs, plural, if singular or plural, lacks standing, the case gets dismissed without ever considering if the case is worthy on the merits, if there's a case there or not. And the opinion states, quote, "At this stage, neither the individual nor the state plaintiffs have established standing to seek an injunction against any defendant. We therefore lack jurisdiction to reach the merits of the dispute." Close quote. In pro football, they call this a punt. Think of standing as having skin in the game. A party seeking an injunction needs to show that if the injunction is not granted, the defendant's actions will cause immediate specific harm to that plaintiff. The opinion noted that the social media platforms were not named in the suit. The only defendants were the federal government. The social media platforms were not named. And the evidence showed that these platforms had moderated third-party content before any of the alleged wrongful government actions had occurred. Some of these posts were moderated, were limited based on the platform's own decisions, and some was based on what the government, they say allegedly caused by the government. And you couldn't tell which was which. Hence, any alleged harm could have been caused by the platforms following their own policies and not by the governmental agencies. Now, the Supreme Court noted that other factors indicating a lack of standing. I'm not going to bore you with them. It gets very technical when there's multiple parties. Now, the dissent was written by Judge Alito, joined by Thomas and Gorsuch, the hardest of the hardcore reactionaries, in my opinion. They argued there was standing of at least one plaintiff was enough, and the government's action was, quote, blatantly, close quote, unconstitutional and violated free speech rights of both the named plaintiffs and unnamed citizens who have a right to see the posts that the government wanted suppressed. His dissent noted that social media platforms have a right to moderate third-party content, just as the newspaper has the right to decide what to print and edit the letters that it prints. At the same time, free speech protections prevent the government from directly or indirectly telling the platforms how much they should moderate content. Because they never got past standing, we won't know how the majority would have decided free speech claims. I think that neither Roberts, Barrett, nor Kavanaugh were prepared to rule against, in this case, against the Biden administration, where the evidence wasn't clear cut, that it didn't show that this government action caused this platform to edit this post that changed its meaning. That specificity was not involved in this case. So I don't think this case is going to be the final word on the issue. And I think it's possible to get past the standing hurdle. And here's how to do it. If a plaintiff if you get two plaintiffs, one was a poster and one was a reader. One was a poster of the third-party content that was moderated. Another one was a reader who says, I would have liked to have seen it. And they allege that there was a conspiracy between a specific governmental entity and a specific platform to quash or otherwise negate the message of specific posts, including this specific post. And I'm not prepared to predict how Roberts, Kavanaugh, and Barrett would rule if that were the situation before the court. But that's not what was before the court in this case. And so they took an easy way out. They didn't rule on the merits. They found that, hey, you guys, basically, this is bad lawyering. And the district courts that said you were right made bad decisions because they didn't recognize that this was bad lawyering. Just as the people who defended Prop 8 didn't have standing because they didn't represent the state of California before the Supreme Court, so too, these people don't have standing because they cannot show that this specific decision deprived them of seeing this specific or deprived them their post of being distributed in violation because the government interfered. Now, the court makes it clear that if the social media is acting on its own, free speech doesn't apply. That becomes clear in this case, which was decided in March or April of this year. Now, the other case involving free speech on social media are the Moody versus Net Choice and Net Choice versus Paxton that were decided a month or so later on one of the last days of the terms. Now, Net Choice LLC is not a social media platform. It is an organization like the Chamber of Commerce. It's a voluntary organization whose members are social media platforms. And these cases were consolidated on the last day and decided together on the last day of the terms. Now, here's what's involved in the cases. Florida and Texas had each passed what basically a fair comment law. Their state laws that restricted the ability of social media platforms to control whether and how third-party posts were presented to other users. Their new state laws limited the platform's, quote, capacity to engage in content moderation, that is, to prioritize and label various messages, videos, and other contents their user wished to post, close quote. And each law required that platforms inform the poster when the platform moderated that person's content. The district courts in each case examined these laws in the context of the major social media platforms, Facebook, X, TikTok, Instagram, the ones that are basically out there, the big ones. And the district court in each case ruled that the law was invalid because it violated free speech for the state to tell the platforms how it could or should or could not moderate third-party posts. The Fifth Circuit, on its face, held that Texas law didn't abridge free speech and denied the injunction. So Texas law is okay. The 11th Circuit, which had the jurisdiction over the Florida law, held the opposite. It said the law violated the platform's free speech rights and enjoined its enforcement. So the Supreme Court took both cases to resolve the conflict between the two circuits. And what did it do? It punted. It vacated both of these decisions, said you're both wrong. And the majority opinion said that neither the Fifth Circuit nor the 11th Circuit had properly analyzed how the state law in question impacted all the entities to which it applied. And all 9 justices agreed on that much. When a plaintiff seeks to enjoin operation of a law in every possible circumstance because the law is unconstitutional on its face, that means no matter how you try to apply any part of this law, it's going to violate the Constitution. If you're trying to enjoin a law from going into operation, that's what you got to prove. That it's unconstitutional across the board. Otherwise, you have to wait till it applies to you, till they try to apply it to you and say, no, as that law applies to me, it's unconstitutional. But here, Net Choice is trying to get each of those laws declared unconstitutional on their faces, right off the get-go. And in such case, the plaintiff has the burden of showing why the law would be unconstitutional in every possible application to every possible impacted party. In other words, the court must ask and answer what activities by what actors does the law affect and how might they be affected. Now, that isn't what the lower courts did in this case. And because the Supreme Court is a court of review, it's up to the lower court to do that. We're not going to do it for you guys. So we're going to send both cases back to you. So you should do it right. And the problem was that neither court, they only looked at these cases as they related to Facebook and TikTok and Instagram, but they didn't ask how they relate to Yelp or Wikipedia or Google or any other site that accepts that you can upload anything into that are not, that are more specific. Here, the record reflected that the district court and circuit courts in each case had only analyzed how they applied to platforms like Facebook, X, TikTok, and Instagram, and YouTube, which primarily were outlets for content by third-party posts by third-party content on anything and everything. But neither the district court nor the circuit courts in either case analyzed how these state laws might impact every possible moderation of every third-party post on a slew of other platforms. Up there, such as Yelp, Yahoo, Travelocity, Wikipedia, Uber, Google, Venmo, PayPal, eBay, WhatsApp, WeChat, and on and on and on. The majority opinion was written by Justice Kagan, and it was joined in by Roberts, Sotomayor, Barrett, and Jackson. So you had you had 6 justices that went along with the majority opinion. But Justices Thomas, Alito, and Gorsuch joined only in the judgment. They didn't agree with the opinion statements because what the opinion did, what Kagan's opinion did, what 6 of them agreed with, was that after they said, okay, you guys did it wrong, so you'll know what to do on remand. Let me point out some mistakes. And the mistakes were the 11th Circuit got it right and the 5th Circuit got it wrong as to the major platforms that they analyzed. And interestingly enough, Alito, Thomas, Alito, and Gorsuch disagreed with that analysis. What's important to me is that Barrett and the Chief Justice did agree with that analysis. So you seem to have 5 justices on record that Texas got it wrong. The majority's opinion said that as to the big social media platforms, which the district and circuit courts had considered, the 11th Circuit got it right, the 5th got it wrong. Content moderation by the major platforms is protected expression. Just like a newspaper decision as to what letters to the editor it's going to print is protected expression. It may reflect, if it's possibly going to reflect a point of view, it's protected. Not that it does reflect a point of view, but if it's possible that it's going to reflect a point of view, it's protected speech. A government or a state or local, any entity, a governmental entity may be unhappy with a platform's power to shape public opinions or perception, but freedom of speech deprives the state of the right to regulate the platform's moderation. That's what they said. That's what the majority opinion basically said as to why Texas got it wrong. And as to that aspect of content, what appears on the website. Justice Barrett wrote separately. She wanted to suggest a number of other factors that needed to be considered. Algorithms that have nothing to do with expression or viewpoint might not involve free speech. AI-generated moderation that isn't content-centered may not affect free speech. A post may contain a worm or other non-content specific problem, such as a virus or some problem with its format. Its format is incompatible. That doesn't affect free speech. Filtering posts based on what a user says they'd like to see may not affect free speech, because a user has rights too. She also noted that foreign speech is not within the First Amendment's protection, which is absolutely true. So what about a foreign-owned social media platform or foreign content-generated third-party posts? Should it make a difference, she asked, and she doesn't answer this question, if the policies, the expressive content of foreign-owned platforms are administered by American employees? TikTok is a Chinese-owned company, but it's run here by American employees. Does this make a difference? She noted that these and other questions all have to be considered by the lower courts if you're going to hold these laws unconstitutional on their face. Now, Thomas argued that the majority's so-called guidance to the lower court was unnecessary. He's probably right there because it's not necessary to the decision. And that as to the Fifth Circuit, they were wrong. Platform moderation policies do not always constitute expressive content in his view. Further, the internet, he says, is a common carrier. for which there are separate rules regarding access or use. So he says it's like, he argues that it's like a toll road. There may be numerous newspapers and broadcasters, but there's only one internet. And those who use it can't limit what is seen or not seen, just as a privately owned toll road has to accept anybody willing to pay the toll. So that he argues that open source internet platforms must be open to all with no right to moderate. But I would ask you, is the internet really like a toll road? Because there are an infinite number of sites on the internet. Anybody can create an HTTP and create a website. And the ability to have other people see that website is limited only by your ability to pay for the advertising to make it known. So I would argue that Thomas is wrong, that the internet is not a common carrier. Because it has an infinite, there is no such thing as an infinite number of toll roads. There is an infinite number of websites, There is no limit to the number of websites. So that's what I think of Thomas's opinion. Justice Alito took 33 pages to explain his view that NetChoice, the plaintiff, didn't have standing to object to either state's laws. NetChoice is not itself a social media platform that's potentially impacted by any state's law. And under the Murphy case, the same decision in the Murphy case that we made, NetChoice as an entity doesn't have any skin in the game. Well, the argument that's wrong there is that there's authority that says that an association of members whose members are all uniformly, whose members are impacted, has the right to speak for all members. So I think he's wrong there. And so he takes 33 pages, not only to tell that, but to also argue that the majority's comments about each circuit court's understanding of how free speech might apply was wrong as to the Fifth Circuit. He thinks Texas was right. And that otherwise it was unnecessary, unjustified, and should not have been said. So that's NetChoice. It also didn't really express the issue, but I think you've got something there. If the Chief Justice and Justice Barrett joined Justice Kagan's opinion unreservedly, and that opinion said that as to Texas, they got it wrong to the major sites, I think you know which way the court's going to end up going on whether or not free speech and social media. So to summarize, I can't say that it is or isn't constitutional for a state law to regulate how internet platforms moderate third-party content. That issue, the substance of the issue, has not yet been decided. It wasn't decided. I think we have an indication which way it will go as to the major sites. Something like Yelp is completely different, or review sites like Travelocity. They can, and again, generally, free speech does not apply to third parties. So if Travelocity wants to have rules regarding what kind of reviews it's going to allow to be posted, it's going to be able to enforce those rules. And the government can't tell it what rules it should adopt to a moderation policy. I think it's crazy to let 50 states write laws about what social media platforms can and can't do. The internet does not know state boundaries. If there's anything that cries out for having any regulation be applicable nationwide, it is the internet. It should be up to Congress if more is needed. I don't think California or Texas or Florida can limit what the internet's going to do within that state. It's impossible to enforce. If you're going to have national rule, if you're going to have a rule at any level, it's going to have to be national. And I think maybe this is something that, because the internet is, it would be nice if it were international. I mean, and besides which, whatever the government decides, you can bypass that by getting a virtual private network, what's called a VPN, and you can get anything and everything anyhow. So I think the court should have held that any attempted state regulation of social media is preempted by federal law. I think because Roberts and Barrett joined in Kagan's opinion in the net choice cases, there are 5 justices who believe that state laws aimed at leveling the ideological content of news feeds and homepages violate free speech. But we're going to have to wait and see. This is our last session. I've enjoyed preparing these, and I hope you realize I have. And I think it's presumptuous to make plans far into the future, especially at my age. I'm 82 years old, but I hope to be back next fall, and I'm all ears as to what you'd like to hear. Yeah, I got several of them. He had his hand up first. Yes, sir.
Can you elaborate the background that we can have anonymous free speech?
Yeah.
And the question is?
The question is, can we have anonymous free speech? Yeah, you can write an unsigned letter to the editor. There's no place that says if you post something in the internet, you have to put your own name on it. And the government can't tell you that you have to. So you can post whatever you want. You can create a bot, or you can hide your identity, hide your IP address. Many people do that. It's called the dark web. And you can be totally anonymous online. I know people who have made up names on their Facebook accounts because they don't want anyone to know who they are.
Well, I know it's being done. I'm just wondering where it came about. So, and people outside of the United States have free speech inside of the United States?
No, they don't.
Well, then how, if it's anonymous, can you tell?
Good point. I don't think you can. And that's the big problem. Police have that all the time. Yes.
So, given the Supreme Court's ruling and the guidance that was provided in the jury opinion, where does that leave the district courts now in terms of being compelled or?
The district courts have to rehear the case.
Both do.
Unless the plaintiff decides, we're never going to be able to prove this. It's too much, it's going to cost too much money, and we don't care about all those other sites. So Facebook, you're just going to have to live with this law. And the first time the state says you have to do something, you'll file a lawsuit based on that law. And then you're going to get a definitive ruling. I think that's what's going to happen. Because I don't think net choice is going to take the time or the money that it's going to take to try and cover how these laws might apply to every conceivable thing. Or they might refile the case and limit its application. They might say, we only want these laws to be declared unconstitutional as to these specific entities under these circumstances, in which case they'd have to make a ruling. Mark.
So we began this talk about comparing the internet to the automobile.
Yeah.
The impact of each of those, there's no question, was enormous. It affected the way country thinks in all kinds of ways. The difference between the internet and the automobile is, for me, a question of pace. The internet and the technological change is happening so fast and it takes so long for these cases to run through the courts and everything, that by the time they decided, often there's a whole new thing that's out there and challenging. The AI is now involved in this. Okay,
I got it. Mark's comment, for those who couldn't hear on Zoom, is that the difference between comparing the automobile and the internet is one of speed, and that changes in the internet happen so fast that by the time cases get held, frequently the issue is obsolete. And that's a very good point. There is no answer to that because the courts are not going to move that fast. The point is that the law generally works in generalities, and those generalities are going to be there. I'm a firm believer in that difference. One of the things that I object to about the internet is that people expect an instant reply, and we get instant access to information and have zero time for contemplation. And there's a major difference. I make it a rule not to respond to substance emails for at least 24 hours, just so I can think about what I'm gonna say. And a lot of times I tell people, I'm gonna have to get back to you on that text. I'm not gonna answer it right now. For that reason, that I'm just not gonna respond off the seat of my pants. Because half the time I do that, it's the wrong pants in the wrong seat and I'm wrong. And I'm full of what's at the bottom of my pants.
Yeah, but so the problem, of course, is that your judgment is perfectly reasonable about that. But the whole society seems to be operational on this instant response and the expectation of it.
The only thing, Mark's comment is that, it might be reasonable to suggest what I just suggested, but society doesn't work that way. That society is trying to respond immediately and going at this rapid, quick speed. And the only thing I can say is that law generally speaks to the lowest common denominator. And there's not a lot you can do about it.
Right.
Cases are going to take a certain amount of time to prepare. And I know that. I know how long it takes to draft a good complaint. And I know how long it takes to litigate whether or not that complaint states a cause of action, and how many times it can go through the mill, and how many continuances it takes to have that happen, and how long it takes to get witnesses together, and how long it takes to draft stuff, and how much it costs. I used to say I couldn't afford me when I practiced law. I knew what my billing rate was, but I couldn't afford to pay it.
So the thing that leaves me only a question, I certainly have no clear opinion on this. Does this mean that in these issues, the courts and the legal system and law is going to be irrelevant?
It's not going to be irrelevant. It's going to be relevant. It just not be as timely as you'd like it to be. Because the question is, can a state direct a person to moderate content? And the answer, I think, is clearly no. How it gets determined that is going to be, depends on the lawyering and the way that case works its way through the courts. And I don't think anyone's going to get thrown in jail, or any web social media site is going to be off the internet based on any one of these state laws. That's my opinion. We'll see what happens. Anything else? Yes, sir.
Yeah, I want to rebut some of your poo-pooing of the ability to restrict access to children.
Okay.
I think people don't interact with the internet the way you described. Children use phones. That's how they.
Right, and phones you can.
And yes, and phones are generally paid for by their parents, and it's much easier to put in restrictions. The reason we don't have them is because there's a lot of money in having these people. And
I have a technological question.
okay.
Let's assume for the moment that there's a law that states that to get a phone, you have to disclose your true age. And then if that's the case, does a service provider, an internet company, have the ability to block its signal going to a phone that's on record of owned by a person that's underage?
I mean, the software in the phone to do that, sure.
Yeah, the phone can do that, but can the internet provider do that from where he is?
It could be. I don't think you want the internet provider tracking this.
Yeah, but could you require the internet provider to do so? Maybe not. Now, you can require can you require a parent to turn off its phone, what its child can access on the phone? Yes, you can. And a lot of parents do that. Phones have V-chips.
Right. Our websites and social media today are not forced to restrict access. They should be, and that's why we have laws within individual states and individual countries trying to do that. Federal law takes way longer to achieve anything.
And federal states and other countries don't have the First Amendment. And to what extent does the First Amendment protect, restrict, don't take it, let's get away from obscenity for a minute, because that's more cut and dry. Let's talk about political speech. Let's talk about just stuff that's Do we have does the state have the right to tell an 11-year-old that that 11-year-old should not access any post dealing with anything other than obscenity under the First Amendment?
Yeah, but I'm disappointed you put obscenity aside, because that's, for most parents, is the big worry.
Well, and for most parents, they have the ability to control that to the extent that they control their children's phone. Our law says it's up to the parents.
They have those controls today.
What?
They don't have those controls today.
They could. A parent can order a phone that the child cannot change the access code to.
Right.
A parent can change the computer as to what a child can access on that computer.
What you can't do today is get the social media sites to really, I guess this is a.
Yeah. And I'm not sure you can, and I'm not sure the court would allow that to happen because it may restrict that social media site to an adult. An adult has a right to see that social media site.
It's about reasonable measures.
Yeah, but if the reasonable measure, if the measure is by definition unreasonable under the First Amendment, if it blocks access to a consenting adult.
Yeah, I wasn't thinking it would.
It would. But take my word for it, I'm citing the First Amendment tonight. Any other questions? Okay, thank you, everybody. It's early lunchtime. Oh, yeah. Hopefully I'll be here to have the energy to do this.